are doing especially since last 2 months, we are doing much more regular, frequent webinars. So before I introduce our guest speakers today, let me just give a quick introduction about myself. I am Kishore Ramaraju from Houston, Texas. I am a resident of Sugarland, Texas, and one of my passions is to share information, connect the subject matter experts with our group members. I'm the founder of a group called Indian Desi Friends, where we have over 30,000 members across USA. As part of this group, we organize various webinars with all different type of subject matter experts, whether it is immigration or taxation, medical, investment strategies, business opportunities, IT technologies, meditation. We had over 250 plus webinars and seminars in last 2+ years, especially last 2 months because of this COVID impact. I thought like rather than wasting time on reading some panic messages or fake messages, I thought this is the best time where we can invest on ourselves, learn some new concepts, new things which are important for each and every family. So I organized over 35 plus webinars in last 2+ months. And there are a few more webinars in pipeline. One of them is like if your kids are planning to get into medicine. So two famous doctors from Houston, they are going to help or counsel the kids on what are the various qualities they need to have, how they need to prepare, all those things. It will be in a week from now. I'm also talking to one of the subject matter experts on forex trading and also one of the education counselors on kids college admission process. Because most of us are first generation in this country, because of lack of education, lack of awareness, we realize things very late until kids are in high school. At that time, we realize that there are so many things we should be ready with, and so that's why all these sessions are very much helpful to the community. Every session we got around 400 to 500 members. So these are high level sessions which we did in last two plus months. One of them is mainly into kids and college education, how to get into elite colleges, college financial planning, preparation for SAT, ACT, 529 plans, why AP courses are important, about college essays, how high school students should plan for a career in medicine, college admission changes which are beginning in fall 2021, innovative ways to lower college cost of attendance, and then related to investment and career, about future of affiliate marketing, how to build wealth in recession, ABCs of Bitcoin, passive income from real estate investments, data science with Python, fun with Python for kids, scaled agile certification training, uh, Python for kids, technical analysis charting. And also we had various sessions on take charge of your mind, impact of immigration visa extension due to Corona. Rahul, Rebecca, Emily, they did multiple sessions for our group members on the travel restrictions, visa extension process, delays with the visas, and mortgage refinance, basics of gardening. We did a lot of sessions. So in case if any of you are interested, please go to YouTube, search on my name, Kishore Ramaraju, and you can watch majority of the recordings of these sessions, which we had with Rahul and Rebecca also. Just like 1 week before, we had one session on travel restrictions. Now, it's my pleasure to introduce our guest speakers today. First, Mr. Rahul, who is founding partner of Reddy and Newman PC, one of the top attorneys in the entire country, member of American Immigration Lawyers Association since 1995. Rahul is practicing employment-based immigration since last 23+ years. Rahul and Emily and team arranges daily free conference calls to our group members and also to everyone, where they answer questions on various frequently asked items, daily 30-minute calls. So feel free to use that opportunity. You can go to Reddy and Newman PC, or I'll also post a group link where you can join the group link and where you can know about these daily calls. And also Rahul and Emily arranges these weekly immigration Q&As on Facebook and YouTube Live. You can also attend those sessions every Tuesday, I think around 5 p.m. They do have these sessions where they share about all the new updates which are happening in the immigration area. Now, Rebecca Chen, another guest speaker today. She represents clients in employment-based non-immigrant and immigrant visa cases. She got a great experience and a great knowledgeable resource for complex business immigration matters. So thanks, Rebecca and Rahul, one more time for taking time to explain about what is this new memorandum. Is it going to help? Right, there are a lot of questions. Or should we all feel happy that we don't need to get like 6 months extensions, 1 year extensions? Is this new memorandum going to help all the H1Bs in getting 3 year extensions if they all have I-140? And do they not need not worry about the denials, or what it is really going to bring? And also, if you can touch upon the travel restrictions, what is happening with it? When can we expect that travel restrictions come into force? We can also please explain that so that any members who missed the previous session can get high level information about that. And after that, we'll basically open for the Q&A forum. Thank you. And it's all yours, Rahul and Rebecca.
Thank you, Kishore. Maybe it seems that some people are addicted to smoking, some people are addicted to drinking. Kishore is definitely addicted to webinars. That's good. You're conducting all these things for the welfare of the people, Kishore. I'm very proud of you. Considering this memo that was issued as part of the settlement with the ITServe, I'm one of the founder of the ITServe organization. I'm the founding member of the ITServe organization. So it definitely is a good thing. There's no question about it. The memorandum takes back two memos. One is the memo that was issued in 2010. It also takes back the memo that was issued in February 22nd of 2018. It does impose some more extra restrictions on this memo. I'll speak on that later on though. There are two main reasons why we are seeing H1B denials in the past 3 years. Since the time this memo came in, one is the specialty occupation that is not covered by this memo. One is employer-employee relationship, especially when a person is working at a third-party location. To establish an employer-employee relationship previously, based on the February 22nd, 2018 memo, it is required that you should provide end client letter, vendor letter. Sometimes, they did not, they emphasized also on you might have to provide the contract between the vendor and also the end client. And there's a master service agreement. You also have a statement of work. Sometimes if there are 2 or 3 consulting or main vendor, the secondary vendor, and then your consulting company, the USCIS used to burden with all these things. How can you get a main contract, a master service agreement between Deloitte and Pepsi? I took the names as an example. So that was very hard for the companies to obtain those things. Even if you were working directly with Deloitte, they don't want to release that information. Secondary aspect was that the end client have to give a letter, and then end client have to give a clear job description. And the end client have to mention, this is our interpretation, the end client have to mention that this position requires specialty, this position required a specialty degree. And these are all the extra burdens that were imposed. Definitely, as far as the employer-employee relationship is concerned, this memo is a good deal for us, absolutely good deal for us. We're hoping that the interpretation of the memo, they're going to stick with the law. Although Trump administration has a history of never sticking with the law. And the reason why we got this memo is the judge would have ruled in our favor, so they got away by giving this memo so that we are satisfied and backward. We need to see how they are going to implement it. In this particular memo though, they said that the end client vendor letters and all those things may not be required, but they left the option open with regards to the specialty occupation, which is also one of the major reasons for the H1B denial. The second is that, Kishore, the short-term approvals. I know that we used to get short-term approvals 6 months, 1 year. I've seen even 1 day H1 approval sometimes though. This memorandum takes back, to an extent, it takes back with regards to if the employer is certifying that they have a job. If the LCA says they have a job, why do they have to go back to the end client to get the 3 years date? Normally people file for 3 years. So that definitely that definitely has been taken off. However, though, The USCIS have left the door open by inserting that previously, Kishore, when they used to give a short-term H-1B approvals, you ask for 3 years, you get for 6 months or 1 year. They didn't used to give any explanation whatsoever at all. They just used to give approval only 6 months to, they just used to give approval less than 3 years. Now, in this memo, Kishore, though, although it looks very good, they left the door open. They said that if we were to give the H-1B extension lesser than the time that they have requested, we will give, the USCIS has the burden of giving a written explanation why they are giving a short-term approval than that of the long-term approval. So it's good in a sense, but we don't know. At this point of time, we are receiving H-1B approvals, very fast and for 3 years right now. But going forward, the USCIS may adapt where they may get trained, and then they may get to a situation where they may still give the short-term approval, but they should give an explanation why they have given the short-term approval. Rebecca, I know that to an extent that the end client letter is not an absolute requirement for a 3 years approval. What reasons would they give to give the short-term approval when the LCA and the employer under the perjury has said it's 3 years requirement? What reasons could you think that they may give though in future?
I think the only other reason might be that the applicant or the beneficiary no longer has enough H-1B time left in their 6-year limit, and maybe they don't have an I-140 approval or a labor certification. Besides that, there aren't that many reasons why an H-1B period of stay would be issued for less than the requested 3 years if they are taking that kind of need to document 3 years of continuous uninterrupted work. If they're taking that off the table, and if there is a valid LC time, and if the H-1B beneficiary is eligible to get 3 years because they haven't reached their 6-year limit, or they have an I-140 approval or something like that, there aren't many other reasons why an approval should be shortened like that. So this memo, it's pretty cursory. It's at the very end of the memo where they address the short-term approval situation. They basically say that short-term approvals, if they are issued, would need to be justified. And the only example given actually in the memo for why a short-term approval would be given is if the submitted certified LCA didn't cover the entire 3 years that was requested in the I-129 form. And it's very rare for that to happen anyway. So yeah, it kind of, that's one of the areas where we'll need to kind of wait and see and observe how USCIS implements this new policy, if they're still going to try to do short-term approvals, but just justify it, like the memo kind of leaves the door open for. Yeah, if they are going to justify short-term approvals, they likely, like Rahul said, will need to train their officers to write proper decisions on justifying those shorter approval periods. So that's going to take time. So we may not see it right away. They may be in an adjustment period right now, trying to figure out how to comply with this memo, which is basically they're being forced to issue in order to comply with that court order.
Rebecca, can you explain what's going on in the Washington, D.C. with regards to the executive order? Now Trump is going to have an indoor rally with the COVID situation going on. And do you think, this guy is going to do something which is not good? Do you have any information on this? And what is some official, information telling about this executive order? And also, can you explain, does that executive order has anything to do with the people who are in USA?
Right, so this is the extension to the existing executive order that we've all sort of been anticipating for a couple of weeks. And like we discussed on this previous webinar here, it is expected to affect people with H-1Bs, L-1s, H-2Bs, and J-1 visa holders who are currently outside the US. So those in those visa classes who are outside the US at the time the new executive order becomes effective. We do not expect it to affect anyone in those visa classes who are in the US maintaining valid status. So anyone in H-1B, L-1, J-1, H-2B status who is here in the US right now, who has valid status, should be able to stay here, file extensions, file transfers, amendments, everything that you would normally do related to your H-1B or L-1 status, you can still do as long as you do not depart the US. So our main advice, a couple weeks ago and still now is also don't depart the US if you can avoid it, because once that executive order is issued, it will likely become effective very quickly and you may end up stuck outside the US. So it will mainly affect anyone outside the US. In those visa classes, they likely will be barred from entering the US, and the executive order is for these specific classes because the administration is justifying it by saying that we're barring these work visa holders from coming into the US because of the high unemployment rate here right now in an effort to reduce the unemployment rate among Americans. So that is the purpose of the order. We have been expecting it kind of any day now. There were some additional reports just this afternoon that these are still rumors. They're reports, they're nothing definite, but they do seem to be kind of reliable reports that the administration basically kind of finalized the details of the order earlier this week, and that an announcement is expected anytime now, like within the next 24 hours, possibly, because the president does have this rally scheduled in Tulsa, Oklahoma tomorrow. Given his kind of defeat on the DACA issue earlier this week from the Supreme Court, it's expected that he's going to want to be able to point to something else immigration related during this rally tomorrow with his base. And so it's expected that the details of this new executive order will likely be announced tonight or tomorrow morning so that the president can refer to it in his rally that's scheduled for tomorrow. So those are kind of the reports right now. If it doesn't happen in the next 24 hours, it is expected that something will be announced before the end of the day, June 22nd. And that's because that is when that original 60 days of the existing executive order is set to expire. And so this new executive order is meant to be sort of a renewal of the original one. So most likely within the next 24 hours, we will hear something, if not almost definitely by Monday night.
I'm having some difficulty with the audio, guys. If I were to give you a judgment, with regards to the executive order, Rebecca, okay, if you were to judge how much percentage of chance is there, I'm not going to tell you, if, in the next 1 month at least, how much percentage do you think so you have a chance of getting this one executive order in the next 1 month?
Almost definitely in the next 1 month, I would say.
So I would say that you are expecting it to be 99%?
Yes, unless something, we never.
Of course, you have to leave the 1%. Now, you said rightfully with regards to the DACA, the Supreme Court went against Trump administration. We expected that the Supreme Court will be in favor of Trump though, but they went against him in this particular decision. What makes you think that when we challenge this thing with regards to the temporary ban, we won in the IT survey. Every damn case that we go to the court, we are winning against the government on the immigration. So how sure you are that when we go to the court on this executive order, that the courts, will be in favor of Trump administration?
Well, the executive order being challenged in court is somewhat of a different matter. The Supreme Court's decision earlier this week on DACA, the reason that they ruled against the administration was less about the substance of the DACA program itself. Rather, it was the court's problem was with how the administration went about trying to eliminate it. So according to the Administrative Procedures Act, there are rules, there's a process that you need to follow when you're trying to get rid of a program like DACA. You have to make sure you consider all the implications and give basically sound reasoning to make sure that the elimination of the program is not what the court called arbitrary and capricious. So that was the basis of the DACA decision earlier this week from the Supreme Court. Basically, the court was telling the administration, you can eliminate DACA, but in this case, you didn't do it correctly. You didn't follow the correct procedures. With something like the executive order that is expected to be announced in the next 24 hours or over the weekend, it's more likely that if it did get challenged all the way up to the Supreme Court, it's more likely that the Supreme Court would uphold this executive order because it doesn't affect people who, the way that we're expecting it to be issued, the executive order, it wouldn't affect people who are here in the US right now. DACA, eliminating it or not, it affects people who are here in the US right now. This executive order that's going to be issued this weekend most likely affects people who are outside the US. As it does the 60-day order that was issued a couple months ago. It affects people who are outside the US. And the president's power to restrict people who are outside the US is much broader. And we have seen the Supreme Court uphold the president's power to bar people who are currently outside the US. That's what we saw with the so-called Muslim ban. The Supreme Court ended up siding with the Trump administration on that because it affected people who were outside the US from coming into the US.
Well, it looks like we got saved by one, but looks like we're going to go into bigger danger than this one though. Any other things? Kishore, you have any questions? Before we go to Q&A? Kishore, we can't hear you. Kishore, I can't hear you. Can you hear me? Kishore, I can't hear you.
Yeah, I can't hear Kishore either.
One thing I want to discuss about this memorandum is that, if they have given short-term approvals, can we now go and request the USCIS? They are going to issue the longer period of approvals. You have to either file another extension or you have to go to the court system. They're not going to automatically do it by you requesting them. And also, if you have filed any motion to reconsider, or if you filed any court cases, there is a good chance that your H-1B will be, there's a good chance that your H-1B will be up to 2 years if it's been denied because of the employer-employee relationship. Kishore, can you? Kishore, we can't hear you.
Oh, okay. Is it better now, Rahul?
No, much better.
Okay, cool. One of my first questions is any updates on this H-1B filing fee? I saw some rumors that it will increase to $20,000 like that. Is there any update on that?
Rebecca?
Yeah, that is one of the rumors floating around. That seems like one of the more extreme rumors. So that is part of some reported regulatory proposals that the administration is supposed to make maybe next month in July. So those are not executive orders, but proposed changes to existing regulations like the H-1B, H-4 EAD, STEM OPT. So there have been different reports about these possible proposed changes, including that the administration might propose to increase the filing fee of an H-1B application to $20,000. In our opinion, it's very unlikely that that would end up being one of the proposals, or even if it is, it's very likely that it could be challenged right away in court and most likely not implemented until it's gone through the court system, because something like that is so extreme. It's something that would, immediately impact businesses that are relying on the H-1B, that are preparing H-1B applications now, with, the cost in mind of how much that is going to require to file for an H-1B application. Our suspicion is that the $20,000 rumor is one of those things where the administration, which we've seen them do many times, is to try to float or leak kind of reports of sort of the more extreme things that they want to maybe try, that they're considering trying, and they leak it to the press or different reports, and then they see what the reaction is. And usually anything that's leaked that would affect the existence essentially of the H-1B program is immediately met with pushback from the business community to the White House. They get a lot of feedback from the business community about anything that would jeopardize at least the existence of the H-1B visa, and a fee of that amount would jeopardize basically the existence of the visa. So our suspicion is that that is just one of those kind of more extreme things that the administration is leaking just to see what kind of reaction it solicits, but that it's not likely that the proposal will actually be that extreme, or even if it is, that it's not likely that it would be allowed to be implemented right away.
Okay, cool. My second.
So we believe that he doesn't even have an authority according to law, though, because for any fees increase, they need to justify why it's costing them so much money, unless it goes through the Congress. Congress which is the parliament here. So I don't think that he's going to get anything done in the parliament. That's for sure. We already know. So there is a filing fees of $460. Now, everything else is the Congress passed bill. The fees of $750 or $1,500, and the fraud fees of $500, if I'm not mistaken, and extra $4,000. All these things either have gone through the regulation, and also might have gone through the Congress too. But having executive order, he cannot. Under the regulations also, we seriously doubt he has an authority to do so. Now, even though we do tell that his authorities are limited in immigration, the one exception which was tested in the Supreme Court was that a limited ban for a limited amount of people, for a limited time, he has an authority according to 212F INA. And that's where we're more worried. But as far as the $20,000 is concerned, I don't think so. You should be worried in the near future.
My next question, Rahul and Rebecca. Recently, I came to know from 3 or 4 of my friends that they applied for the extension. They got within 1 week to 10 days, and all of them got like 3-year approvals. So do you suggest that is it good time for members to apply for their extensions, even though it is like 5-6 months away from their?
Well, you don't file 6 months, within 6 months, you can't file more than that. Yeah, obviously before they try to learn new tricks, it's better to file it immediately.
Okay, cool. Yeah, and anything on H4 EAD? Anything happening, Rahul?
We are expecting the H4 EAD to be taken off pretty soon. They have expressed it very clearly that they will take the H4 EAD off. As Rebecca was pointing out, anything that affects the people within the United States, the courts have a very good chance to revert back. If you look into DACA, approximately 600,000 people were being given employment authorization. They tried to undo it, and the court struck it down. So they're now proposing to get the H4EAD off. Emily Newman of our office already started funding, create a fund for litigating the H4EAD. You can go to immigrationgirl.com and you can subscribe to it, and then it may be worth for you guys to subscribe to the fund, because she wants to create a litigation, not when the things come in. She wants to prepare the litigation the day they issue the regulations. We can not like, okay, the regulations are issued, all the H4EAD extensions, we cannot do it. And then we go fight, it may take a long time. We need to prepare the groundwork and have it ready. So I strongly recommend people that who want to have H4EAD, want to continue on H4EAD, go to immigrationgirl.com, and try to look into what Immigration Girl is telling.
Yeah, thank you, Rahul. Let me open it up for questions now. So anyone, you can use the raise hand option and I'll unmute you and you can ask the questions. Satyanarayana Krishnamurthy, you are unmuted.
Hi. Yeah, hey, hi. Thanks for these wonderful sessions. Thanks everyone, the expert attorneys here. So one of the questions that I already had was clarified by Rebecca, that because right now I'm in a situation where I have completed 5 years in my H1 and currently my employer is doing the perm, and then right now my employer is also filing the documentation for RFE for the employer and specialty occupation, this thing. So the question that I had was like, will I still get 3 years, because I just had 1 year including the buffer period and everything considered.
No,
so
no,
I guess
wait. You don't have an I-140 approval, is right?
No, not yet. The perm is yet to be approved.
Your lawyer did not even ask for 3 years.
My employer asked for 3 years, but in the RFE document, they said he is eligible only till next June 2021. What is the additional proof that you have to for 3 years? So.
I didn't even if they give a 3-year approval though, under the current circumstances, because they're not prepared. I don't want you to rely on that. Rebecca, you have a different opinion on this?
Right,
How about
I agree.
If I-140 is approved by then,
I-140, if I-140 is approved, I still want you to file one more extension within the 6 years. You don't want to rely on their mistake. They will strike you back.
Got it. Okay.
So what this IT serve said is that if you are eligible for, and then you should, yeah, you're right. I don't know how your employer applied. He should not have applied for 3 years, because what happens, we have seen cases where the immigration does mistakes, and I don't want you to count. Let me tell you one of the example of how immigration did a mistake. A lot of you guys are very young guys. You guys don't know what September 11th is. You have heard about it, but let me explain you that September 2001, okay? On that day, 19 people strike down the Twin Towers and tried to Pentagon, okay? You guys know the summary of that. The ringleader is called Muhammad Atta. He applied for an F1 visa while he was in the United States. And this guy, Muhammad Atta, was the ringleader for all 19 people. And guess what? In 2003, 2 years after he applied the F1 visa, after that guy's dead, and that guy is the most known terrorist available, okay? I mean, next to Osama bin Laden, his F1 got approved. So what the theory, what we are telling is that even if by mistake they approve it, and I'm not telling you're the nicest guy that I know, Satya, but what I'm telling is that even if they do a mistake, don't rely on it. I've seen them doing mistake and coming back and striking people back. You must have the eligibility at the time of filing the H-1B extension for 3 years. Not later on acquired, you're not eligible. So they may give you 3 years, but I want you to do one thing. File the extension again.
Perfect. The other question that I had is I saw the memorandum agreement. It says agreement between two parties related to the yesterday's or day before yesterday's agreement. Will there be any kind of challenging with respect to the specialty occupation that is not included in the memorandum? Are you guys planning to challenge that in the court?
IT service already there are two things. One is an agreement. One is the rescind of policy memorandum. I don't know which one you saw, Satya. So this particular memorandum is for public, issued on June 17th memorandum. maybe you saw an agreement between the IT serve and the USCIS. That was done before though. This is an agreement. This is not an agreement. This is open public memorandum. So this is, and then let me answer.
Yeah, I was watching the recent agreement wherein it doesn't mention anything related to specialty.
Both are recent though. Both are recent though. The agreement is recent and the memorandum is recent. The one which is dated June 17th is a memorandum, not an agreement. Now to answer the specialty occupation, yes, we are fighting USCIS on the specialty occupation, mainly because according to the regulations, to prove the specialty occupation, you have to prove one of the 4 conditions. One condition is the position must require a specific degree. The employer must require a specific degree. The industry standard should be the specific degree. I forgot the 4th one. Rebecca does it. Looks like I'm Rick Perry now. And so we have to meet one of the 4 requirements, not 4 requirements, but the way they are implementing is all 4. That has been challenged in the court, and most probably we might get a favorable opinion on that too. Not only that, every time you move a job from one MSA to another MSA, your employer has to go through the amendment process. That is also, the lawyers who have been already being paid the money, and that is going to be litigated too. That's an easy, we are expecting that to be an easy victory because that went through, they just issued an administrative appeals unit has issued a decision on it. And this is, administration appeals unit is not a district court, guys. It's just a branch of the USCIS have said that we have to have an amendment. So we are challenging that one too. That's in the process too.
Any last word on the green card backlogs for ED2 and ED3 categories?
Rebecca, can you explain what were you telling about this backlog? And maybe you, Rebecca has paged me somewhere about 4 o'clock in the evening. Hey, we need to have some more people trained in the adjustment of status. Can you explain why you said it and what are you planning?
Yeah, so we were discussing amongst ourselves this afternoon about the reports from the chief of the visa section at the Department of State, who is basically, he's the guy who is in charge of changing the dates on the visa bulletin every month. His name is Charlie Oppenheim, and he provides kind of an update each month on what he is predicting for the future. And what he has said in the most recent update is that for this fiscal year, which ends in October, ends September of this year, I think there are 25,000 unused employment-based green cards. But in addition to that, because of the existing executive order that is already in effect that bars people outside the US from applying for immigrant visas, green cards at consulates, because that affects mainly family-based applicants. People outside the US who apply for a green card at the consulate, they're usually applying based on a family relationship, not employment-based, because employment-based, you're all filing here in the US, adjustment of status. So because of the executive order, actually one of the unintended maybe benefits of the order is that there are unused green cards in the family-based category this year as a result of the executive order, and those are going to spill over into the employment-based quota for next year. And so there's expected to be, I think he said, possibly a 20% increase in green cards for the per country limits when it's calculated out and spread out. So that does, give us some optimism on movement in the employment-based visa bulletin starting this next fiscal year in October. It's what Charlie Oppenheim said. It was the largest kind of percentage increase that he has seen in recent memory. And he's been in this position for years and years. So it is possibly, kind of the most optimistic situation for the employment-based visa bulletin. Of course, we never know what else will happen. I mean,
Rebecca, this Charlie Opelman statement of the extra 20%, we're speaking approximately around 30 to 40,000 green cards extra, or maybe even more. Is that based on the executive order and also the COVID situation right now? They can't issue the employment base. But it also looks like the Trump administration is going to extend the executive order for the immigrant visa applicants outside the country. Plus, it is also expected that because of the closure in the consulates, closure in the USCIS, at least to be limited operational facilities that they have, do you see that that number may balloon more higher?
Yeah, possibly. If the president extends the immigrant visa executive order, if he renews it beyond June 22nd, which is when it's set to expire, that'll add to the spillover from family-based to employment-based. Also, like Rahul was saying, because of the pandemic, because field offices are, for the most part, still closed and can't do the final I-485 interviews, there will be even more kind of unused green cards that should have been used this year, which will also spill over until next year. So
Charlie Opelman is one of the single guy in the whole administration that I have seen. He thinks something like the Indians and Chinese are the best in the world. I don't know, that's his opinion. I met him personally. He gave his cell phone number to me, and if he has any questions to call. This guy, if ever you guys want to know who this Charlie Opelman is, this is the guy who made prior to date current for everybody in 2007. Approximately 13 years ago. I don't know how many people are there in there, but I am there at that time. He made everything current, guys, on one single day. He said, do hell, you guys are not giving the green card. I have to meet the requirement. I have to face the Congress. I cannot face the Congress unless I put this prior to date. He moved single-handedly the entire prior to date current. Now, having said that, Rebecca, is there a chance for it?
For everything to become current again?
He did it before.
That's true. I mean, I wasn't practicing in 2007, so for me, it's still kind of hard to believe that would happen. That would be amazing, but yeah.
Yeah, and then Satya, you were pointing out a lot of different things that was bringing that proper questions from us is that Rebecca was speaking in the meeting with us in our, she was thinking me, hey, how are we going to deal with it? She was not there in our office in 2007. Guess what happened in 2007 when every prior to date became current and we came to know that it's going to be only for one day, which is July 1st. We started flying into our office. We had to call 911. Believe me, we called 911. We called the police because they were not allowing us. The whole clients came in. I mean, we didn't have an option. We filed everybody on July 1st, guys, but we have to control the crowd. That's exactly what Rebecca was pointing out. How are we going to handle the cases? Yeah, hopefully so, but it'll be very less chance for it, but there's a chance for it. Charlie Opelman, he can do it.
Thanks, Rahul. Vijay, you are muted.
Yeah, thanks, Kishore. Hi, Rahul and Rebecca. So I have actually, my current visa is expiring in September 1st. So I have applied extension in May H1, H4 and H4 EAD. Under these circumstances, now again, the premium processing also initiated last week. So once it is there. Now the question is, my wife current employer, they also filed because he has our own I-140. They applied H1 as well. Now the situation is like, because of we are not sure to approve by this timeline, they applied the H1 as well. Now what are our situations? Now H4 ED in progress and H1 also not applied yet. They are in the process of application preparation.
I-94 expiring.
September 1st.
Of which year? Of which year?
Hello?
September.
September 1st, 2020.
Oh, her H4 is expiring in September 1st of 2020. Yeah,
H4 EAD both are expiring in September 1st, 2020.
I see no problem whatsoever at all. No problem whatsoever at all to have you having H4 plus EAD and H1B pending at the same time. There is something called last action rule that you need to be careful about, but it's not a major deal. There are ways to get around that too. That's called automatic revalidation. So I would strongly recommend you can have them file a H4 plus EAD, and the H1B can be there too. If the H1B gets approved, let's say in the next 1 month, she can continue on the H1. And if the H4 plus EAD approves later on, she will be converted automatically back into H4.
Okay, so H1, as soon as H1 approved prior, and then H4 is approved and H4 EAD, she can continue.
Yeah, when the H4 plus EAD is approved, yes.
Yes, yeah. Okay, if it is a reverse, if it is vice versa, Rahul?
H4 plus EAD is approved,
Yeah.
and then H1B is approved, then she will
Later.
be H1B.
Okay. Okay. So do we need to do anything like whatever it is approved, H1 is approved, then H4 EAD, we need to send any notification for revoking that?
No, don't revoke it. You can
Okay.
play around with both the things by going to Mexico or Canada. Hopefully travel restrictions are not there. And she can come back on H4 if she wants to, or the otherwise too. But don't revoke.
Oh, okay. Then that time H4 is valid and the EAD already there, so she can work vice versa.
A little
Okay.
bit complex for you at this point of time. If you
Okay.
have both the approvals, the recent one is valid. But you can do otherwise by something called automatic revalidation. It's going to be tough for me to explain it. You can do by consulting with a lawyer. There are ways to do it, but right now it's going to be tough to explain. It's going to take about 10-15 minutes for me to explain.
Sure, Rahul.
Yeah, another question related to today's topic is because of this new memorandum, if somebody is not having a SOW, client letter and purchase order, if they just have an appointment and offer letter and payslip, is it sufficient for the visa extension?
Rebecca?
It is a little too early to say right now because as we kind of pointed out earlier, the memo, this most recent memo only applies to the employer-employee relationship issues. And we have seen USCIS still send RFEs and denials on the specialty occupation issue. And the end client letter does relate to the specialty occupation issue, at least the way USCIS is reading the specialty occupation issue right now, because from USCIS's point of view, what they're saying is, okay, if you're working physically at this other company's offsite location, we need confirmation from them because they're the ones who see you day in and day out. We need confirmation from them on their letterhead that you are actually doing software development work and you're not, you know, a janitor, basically. So for that reason, the end client letter may still be necessary. I could foresee them still sending an RFE on specialty occupation, asking for the end client letter in that situation. However, I would say that the requirement that you have every link in the chain documented by an MSA and a work order and a letter from every vendor in the chain, that probably is not necessary anymore because of the memo, because that was related more to the employee relationship and maintaining the right to control through multiple vendor companies. So you probably don't need as much evidence of the multiple links in the chain of the project, but you may still need an end client letter. We'll have to see kind of how the RFEs start being issued after this most recent policy change.
Thank you, Rebecca. Mr. Raj A, you are unmuted. Hi, Raj. Let me unmute someone else. Srikanth Renikunta. Yes, Srikanth.
Hi.
You can. Yeah.
Hi. Sure. Thanks. I just want to make sure about the Indian embassy, like when the US embassy in India, when are they going to plan? Do you have any idea about that?
We don't have an idea about it at this point of time. There are a couple of different things. One is restriction from the US. There is also another restriction from India also to even go to those consulate and other locations too. I've heard that Chennai has put a lockdown right now. So it's going to be tough to estimate and we don't know. At the same time, they are publishing lists of the people who got COVID. I saw that in the CBP website today, the amount of people in each district, the CBP employees that got COVID, and that looks not good at all. So at this point of time, we don't know when they're going to fully open. At this point of time, they're only open for emergencies. I don't know why they are not doing the Zoom and other things at this point of time. We don't know. I spoke with an educational consultant today from a university, very popular university from Boston. And I asked, and she is an educational institute. She is the one who recruits the students from all the countries. So what are you going to do? How are they going to come in August? Because the appointments are not there until February, even if they are, and they'll keep on canceling the appointments. She said, we're going to do it Zoom for the first semester, and maybe next semester they'll be able to come in. That's what they're going to do. So I don't know when this is going to open right now.
Okay, thank you. Thanks for answering. Thanks, Rahul.
If H4 EAD is removed through executive order, does the current H4 EAD having 1 year validity automatically expires?
Even in the proposal in the executive order. They're expecting that to come in the regulations, though. I don't think so it's going to come in the executive order. If it's going to come in the executive orders, we already have a Supreme Court decision, which we just got it. We're going to hit with that, and I don't think so. It's going to be going through the regulatory process. And if it's going to be the regulatory process, the first thing is that will the existing EADs will be automatically canceled? Will the pending applications will be processed? Now, I cannot say anything about it right now, the official information, but let me tell you when the DACA EADs were being canceled. What they said was that the existing EADs can continue. You can file the extension within the next 1 month or 2 months, okay? But you cannot file any more after that. That's what they said. We're expecting that when they dealt with the unlawful people in the United States, they will show the same courtesy, what they showed to them, the H4 EAD people. That's what we're expecting.
Thank you, Rahul. Preetham, you are unmuted.
Yeah, thank you, Kishore. Thank you, Rahul and Rebecca. My question is on the memorandum. It had 2 points, and Rebecca just clarified on the employee-employer relation, wherein we don't have to have all the letters in the link, in the chain, right? So the first one, the specialized occupation, are we still supposed to provide master service agreement, statement of work, itinerary of services, all of those documentation, are they still required, or will there be any reduction in those?
I definitely will bet on reduction on those things. It will definitely be reduction, but could it be that they will eliminate completely? Maybe not. Especially the end client letter, they may give more importance for specialty occupation. But with regards to the chain of documents, I think so that there will be some reduction. What do you say, Rebecca?
Yeah, that would be my guess. If they can't enforce that kind of chain of documents from the 2018 memo, I have a feeling they may try to hold on to as much as they can by requiring the end client letter as evidence of the beneficiary's specialty occupation work on a day-to-day basis. As for the itinerary, the memo actually mentioned that for the time being, I think that officers didn't need to enforce the itinerary requirement mentioned in the memo. I don't know if that means that they are just amongst themselves internally trying to provide more training or decide what the new itinerary requirement might be. What I would probably advise as sort of the safest practice for any applications being filed now, post memo, is to provide as much as you can. If you do have the MSA and SOW, I would go ahead and provide it, and I would go ahead and provide an itinerary, because that's technically still required by regulation, even if the officers are not going to enforce it completely right now. I would still provide what you can, and then we can maybe reassess once we start seeing how they're processing things, how they're interpreting and applying the memo. But for now, I would try to just still provide what you can.
Yeah, but if the date on the statement of work, let's say it's only valid for next 6 months, but I have a master service agreement which is valid for next 5 years, and the petition or the LCA is for 3 years because I have the I-140 filed.
Yeah, Pritam, I am taking the judgment call of not providing the statement of work, though. In that particular scenario, I'm making the judgment call of not providing it.
Okay.
That's only 6 months. They may give a 6 months approval, and then they can give an explanation that, okay, listen, your job is only until 6 months. So they may do that. So I'm taking the judgment call right now to do it. But however, as Rebecca has pointed out, we have to see how the immigration is going to act, what they're going to react. And those things will be when we get the decisions, we will come to know. Nowadays, we're just getting, blanket 3 years approval, boom, 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 boom. So
okay.
That's the cases, but by the time they gather it, they get the information, and they try to act on it, we will be able to inform you more. But at this point of time, I will take the judgment call of not providing the statement of work if it's only for 6 months.
So just go ahead with the master service agreement, which is valid for 5 years.
Yeah, I will do that.
And the client letter, client letter, I have it, and also the LCA, which is filed for 3 years.
Yeah,
so those documentation should be good enough.
I will provide the end date letter on the client letter.
Okay. Yeah, thank you. And one small other thing is, since application service centers, support centers are still closed, any idea when they would open up for the biometrics for the H4?
They said June 4th, and they backed off on it. They said July 13th. Is that right, Rebecca?
I think so. July 18th, I think. They just
13th is my judgment.
13th? Okay. Yeah, sometime in mid-July is the most recent answer from them.
We'll take 2 more questions, Rahul. If someone got I-140, but he got a client letter which is ending at the end of this year, can he still expect a 3-year extension because of this memorandum, or can they still get?
Good chance for it right now. Right now, good chance for it. Yeah. If you can modify the letter where they don't include the end date, though, that would be much better.
Okay. Mr. Prem, you are unmuted.
Hi, Rahul. Hi, Kishore. My question is Rahul is about to asking to Rebecca the question about the memorandum. If suppose somebody applied extension and they are waiting for the result, if suppose that result is denied, so how can we refer this memorandum and how can we proceed?
You can file a court case, and I'm pretty sure the court is going to act pretty quick. They might compromise it as soon as you file a court litigation. What do you say, Rebecca?
Yeah, if it's a pending case, if it's a currently pending case, I think the memo instructed officers to apply the new guidance to pending cases. If it has already been denied, then yeah, I think
still they have a chance of getting to the court and getting it approved. Is that right, Rebecca? I mean, in the court.
Yes. Yeah, in court, yes.
And while in court, we can stay here, Rahul?
Did you say it's an extension?
Yeah, I mean, if as of I know, if you got extension denied, they will give 1 week or 10 days time. We need to leave the country. Am I right?
I-94 expired. Now that's going to have a problem, because what if the court judgment comes negative? Nothing is guaranteed, right? So you have to evaluate your chances and discuss with the lawyer to see I mean, is that worth and what you're going to stay, how long you're going to stay. Because if you cross 180 days of illegal stay, you get the court judgment, you're barred for 3 years. So you have to evaluate that with a lawyer.
Okay, Rahul. Thank you.
Kavita, you're unmuted.
Yes, thanks, Kishore and Rahul. My question is, my husband has 2 H1 lottery has been picked up this time. My question is, can we file via both the consultant, or in the past experience, will USCIS reject both because we filed both 2 H1Bs?
Does he have both jobs? Which company is working for?
Yeah, a different company. These 2 different consultancies have applied.
Company A and company B got selected. Is he working with company A or company B, or is he working for company C?
His company C that got rejected. So A and B applied and both got picked up.
I know. So he's not even working with company A and company C.
Yeah, correct. Yes.
Sorry. Both he's not working.
Yeah,
I
Rahul.
recommend not to file by any of these companies. Don't trust these companies. They're all fraudulent companies. You need to, don't file it. The reason is that people do the things right now that's going to affect them way later on. Recently, we published an article, 5,000 people, or 4,600 people will be thrown out of the country because they used an experience letter from one single address. And I'm wrong in that number of 4,600 because after I wrote an article, there's another thing that came out. We don't even know the number involved in it. It may be 6,000. So if you are telling that he's working for company C and company A and company B are willing to give a job and they're willing to wait until October 1st, I doubt you, Kavita. I
Okay.
think that these are fraudulent companies, and even when the approval comes from them, it's going to have a major problem because all these 4,600 plus people are hit with misrepresentation. And that means that lifelong, they can never, ever step into the country. There's only one limited waiver, that if they're married to a US citizen, a green card holder, or their parents are US citizen and green card holders. So
Actually,
don't do this mistake.
actually, one consultancy is known to us.
Matter if it's known. Matter if it's known.
How to find out the block for blacklisted companies?
That your husband is working for company C and they are willing to file a H1B when there is no job, okay, which is going to wait for him for the next 6 months, is that company is a fraudulent company.
Okay.
If it's a guy that's coming with a dark suit in the night without invitation, and then he's making a hole in the back door, is most probably a thief.
Okay, but actually one company is known to us and they have the job opportunity.
If he's coming in the daytime, that's fine. He's coming in the nighttime.
Okay, okay.
And he's coming with the back door and he's opening the things up.
One more last question, sorry. If imagine both gets, in that one gets approved, one gets...
Wise to continue for you to misrepresent to USCIS. We cannot help, we cannot guide.
Okay. Yeah, thanks, Kishore. Yeah, thank you so much.
Thank you.
Thanks, Rahul.
Thanks again, Rahul and Rebecca. I know you took another 5 minutes more than the planned time. So thanks again, every time immediately requesting or accepting the request and helping all our community and all our members. Yeah, have a great weekend, everyone. Thank you, Rahul, Rebecca.
Thank you, Rebecca.
For having us. Have a good weekend.
Thank you all. Bye.